Hey, welcome back to Biz Talk TV. I'm your business host and guide, Michael Rager. Hey, next we've got our legal experts, Mac and Natalia. They're going to talk a little bit today about Texas and Texas divorce laws. Take it away, Mac.
Hello and welcome again, and thank you for having us. And I think it will be good to talk about things that concern most of the people, and that would be how Texas divorce law works and how can people get divorced in Texas when it comes to that. Mac, can you tell us something about for informational purposes?
So for many people, a divorce is one of the biggest deals of their life. It could be life-shattering for many people. It could also affect their children in many ways, and it can affect your property. Sometimes, well, most of the time negatively, because you're going from two types, two pots of assets down to one and to a single life. So there's a lot involved when it comes to divorce. Basically, divorce in Texas, you have a right to file it as long as you've lived in the state for a certain number of months, in the county for a certain number of months. Once you've established jurisdiction and you file your divorce, then the court can grant your divorce no earlier than 2 months, with some exceptions. But once a divorce is filed, then, keep in mind it is a lawsuit. You are suing the other parent or the other spouse, and they can decide if they're going to treat it amicably or if they're going to contest things. And so many times people do amicable divorces where their goal is to try to resolve their disputes outside of court and just sign papers. But sometimes, especially for divorces where people have been married for a very long time, it becomes much more contested because you have homes involved, cars involved, you have retirement accounts involved, you have children involved in their interests because the court takes jurisdiction over your kids as well. And so the first question I think most people would have is the divorce going to be contested or uncontested, amicable or none? And so that then will decide for you which way your divorce is going to go.
And being already within the topic of the amicable divorce, how does mediation work within the divorce process? Is it advisable to do it beforehand if someone is interested, or can it be done within this process? How does it work? What's best?
So there is such a thing called pre-suit mediation, and that's where parties come together to mediate their case before a lawsuit is even filed. So for example, you're going to do a divorce, you've told your spouse, you are about to file the papers, but you decide, you know what? Let's go talk to a mediator first, and let's see if we're able to resolve our differences before we even do the divorce case. And so in that situation, you contact a mediator like myself, and you book them with the other party, you agree on a date, you go to your mediation, typically lasts about 4 hours to 8 hours, depends on what the contested disputes are. And once you've addressed the issues and you are able to reach a full settlement agreement called a MSA, a mediated settlement agreement, then you can move on to actually filing a divorce. In the court, with a few exceptions, the court has to give you a judgment on that mediation agreement because it came into existence amicably, through confidence, and it was done by a third-party neutral who is in control of the process. And so as long as you satisfy the statutory requirements of mediation, then the court is going to give you a full resolution on it.
And let us imagine I already have the mediation agreement at hand, or the divorce judgment is already in front of me, and something changes in my life. Imagine I need to move to another state, or I need to start a job somewhere, and that will require more driving. I can't be taking care of the kid any longer within the times that were stipulated in the mediation agreement. What do I do? How could you help me?
So there is such a thing called modifications. If your situation changes, yes, you're able to go back to court or back to the mediation table and try to renegotiate the final agreement that you had done last time. Okay, so mediating modifications is something that's very common, but just make sure that there's actually been a change situation that justifies it. In the law, we sometimes refer to it as a material and substantial change in circumstance. Something has to happen that triggers the statute to allow the judge to have power to come back and change the court order. Most of the time, it's easy if it's a child support modification because it's every 3 years typically. But if it's not a child support dispute, you have to modify. But let's say it's a divorce case and then you resolve your divorce. Just remember that the court is only going to have a certain window of time where they can still touch a divorce judgment. Certainly they can touch the children's issues, but when it comes to property division, I mean, the court can't remarry you, okay, after your divorce. I mean, you do that yourself, but the judge cannot undo your divorce once they've granted your divorce. So unlike the child support and the child custody and child support modification issues, when it comes to a divorce, once you're divorced and your marriage is over, but of course you can come back and get remarried if you so choose.
And tell me, the property division, I think that the biggest concern for many people is that, okay, exactly as you started telling me, I am coming out of this divorce and what, am I coming with nothing? How do I do that? Or what do I do with the community house, meaning the house we were both living in? What do I do with the mortgage? Are you able to help with that?
So the issues that are common in divorce do deal with property that encompass everything that's within the community estate, we call it. It's not just the wife's assets or the husband's assets. In marriage in Texas, it's the community's assets. And so, yes, all those assets can be divided and touched in a mediation, okay? But I think the most common problems we get when people come together is people want to keep something, or they want the other side not to be getting something, especially because there was some kind of crime that happened in the marriage. When I mean crime, I don't mean literal crimes, but quasi-crimes like adultery or cruelty, abandonment, things that can touch the heart, that can impact a person in a way that's very, very powerful, that can lead to depression. So sometimes people want to get a disproportionate share of property, like a house, for example, because something's been done to them by their spouse. So a lot of times these things can go to a judge who has to make a decision, but they can also be mediated. Anything, almost anything can be mediated. And so a lot of times we find ourselves resolving very, very sensitive topics and mediation. So if you're going to be talking about your sex life in front of a judge, if you're going to be talking about how somebody made you feel in front of a judge, in a courtroom where it's public, why don't you consider doing it at the mediation table first? That's what we're all about. Conflict resolution specialists who try to help people resolve their differences outside of court, not just in front of a court.
And I want to ask you another question, which is also very important, I think, and concerns many people. What happens if we have children? How would the children be involved in the divorce proceedings here in Texas?
So it's a very big question that we can't get too much involved into, but suffice to say this. Once children are in a marriage, the court then has power over them through jurisdiction when a divorce is taking place. And so those issues as well, when you're dealing with paternity, conservatorship, child support,
Contacts?
Well, contacts, we call it in some countries, but in Texas we call it possession and access or visitation. And so all the issues, all the issues can be dealt with at mediation, and it's up to you to make it happen by connecting the other party, connecting the other parent, having them know about the mediator like myself, and then they'll be able to go to the mediation table and hopefully settle. If they can't settle, that's okay. That's what we have a judge for. But the potential ways this could resolve, you could get a full agreement, you can get no agreement, you can get a temporary agreement, a partial agreement, or a recess, where you come back to mediation after you go sleep on things, because people need it sometimes. It's a lot of life-changing decisions you gotta make, and we want to help you make a good decision.
And this is what we wanted to say to you as independent lawyers and mediators. We would want you to go to our website and check what we can do for you, or see some more informational materials we have, the blogs. But also, please go to our YouTube channel at LMI Podcast, where we are discussing some more issues regarding Polish as well, but also and primarily Texan family law, including all those aspects and elements we have just been discussing: child support, property division, or even prenuptial agreements. So be there, be with us. Thank you so much.
Thank you, everybody.
Hey, thanks a lot, Mac and Natalia. That was some great information. This is Michael Rager, your business guide here on Now Media TV.